In my time as a criminal defense attorney, I've come across many of the same questions from clients. As someone who deals with sex crimes, there are even more specific questions that my clients oftentimes ask. Hi, I'm attorney Brittany, and in this video, I'm going to answer 8 of the most common questions that I get about sex assault cases. Let's get started. Question number 1, does arrest mean that I will never see my kids again? The answer is no. Even after an arrest, you are entitled to a reasonable bail. When it is posted, you are free again until trial or sentencing. However, judges often impose conditions on bail to limit access to minor children. Your lawyer will argue that visitation should continue at least in the presence of a neutral third party or a social worker from the Department of Children and Families. Depending on the allegations, cooperation with DCF and recommended treatment can sometimes result in favorable action in criminal court regarding protective order modifications. If the judge enters a criminal protective order, such an order can restrict your access to your children. Therefore, it is crucial that your lawyer argue for some visitation, however restricted it may be. Question number 2, will I definitely go to jail? The truth is that no one can predict what the outcome of any case will be. That is why it is important to prepare your case thoroughly to present the best defense. Under Connecticut law, a plea agreement with the state can limit the range of penalties and can provide for probation rather than jail. If you do enter a plea, the judge can either accept the agreement and impose that sentence, or the judge can reject the agreement. If the agreement is rejected, your prior plea of not guilty is restored. Question number 3, how can I prove my innocence? The defense case can be proven in a number of ways. First, you can testify at trial. Second, your defense can try to establish scientific evidence such as blood type or DNA, which will exclude you as a suspect. You can also present other evidence regarding the complainant's truthfulness or lack thereof. Witnesses can testify as to your truthfulness or the untruthfulness or motive of the state's witnesses. The range of opportunities is endless, and a good attorney can help you prove your innocence. Question number 4, how can anyone believe the complaining witness? In these types of cases, the complaining witnesses start out as believable, and it is up to the defense to show that the witnesses are incorrect. You should expect that all social workers and law enforcement officers will assume the truth of the allegations. The concept that a person will never lie about matters of sex runs deeply in our society. It is the job of the defense to educate the court and the jurors that this is not always the case. Question number 5, what do I do until the trial starts? You try to regain the orderly process of your life as soon as possible, as hard as that can be. Walking around with the look of a depressed and saddened person may lead others to view you as guilty of the charges. Even though you feel totally helpless and confused, you must try to regain your composure and confidence. If you are able to do so, others who see you will have a second thought as to whether or not to believe the accusations. If you look guilty, so to speak, people will believe that you are guilty of the accusations. Question number 6, can I sue the police and/or witness after this is over? The truth is that now is not the time to think of such things. Concentrate on winning the case. You are not going to successfully sue anybody if you lose the case. Question number 7, if I'm also getting a divorce, should I answer any questions during the divorce case? This calls for a coordinated effort between your criminal defense lawyer and your divorce lawyer. Ideally, there are 2 different lawyers. No one can answer this question in a vacuum, except to say that a strong denial can only be based on a well-prepared defense. Question number 8, if I pass the lie detector test, will they throw the case out? The answer is not necessarily. Under Stevie Porter, polygraph evidence is not admissible before a jury. However, a successful lie detector test result can be useful in plea bargaining and may lead to the state to question its witnesses further. It remains to be seen if polygraph results will become admissible when the trial is to a judge and not to a jury. These are some of the most common questions that I hear from clients, but they certainly are not the only ones. If you still have questions, feel free to contact my office. I'm happy to answer any